much.
Okay. Case number 21 CR 146, State of Ohio versus Robert Woodruff. That's the judicial police to send out. Representative the state's prosecuting attorney Collins, president of the County Defendant's attorney William Undertrial. You are Robert Woodruff.
Yes.
Mr. Woodruff is charged with burglary, a second-degree felony, and theft, a fifth-degree felony. We have a trial date, maybe in December, actually November 15th. The matter was set today for a status conference, and Mr. Woodruff, I've been presented with a plea of guilty form, which indicates that you're going to withdraw your not guilty plea and plead guilty to a reduced charge of attempted burglary, a third-degree felony. Now, this is a 3-page document the prosecutor's office prepares from a form they have in the computer. On page 3, there are signature lines, and there's a sentence about a little, not quite halfway down, that says, I entered this plea voluntarily, and immediately below that, clearly you can see what appears to be Robert Woodruff. Is that your signature I'm looking at?
Yes, sir.
When did you sign this document?
Just a few minutes ago.
Right. And when you signed it, did you understand that it's an agreement to plead guilty, which means it won't be a trial? The next step in your case would be a sentencing hearing?
Yes, sir.
And is this something you have been speaking with your attorney about before you came here today, this possible plea agreement?
Yes, sir.
So you don't feel surprised that this was happening? You had enough time to fully consider this matter before making this decision?
Yes, sir.
Are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
All right, now, the agreement states on page 1 that they're going to reduce the charge to attempted burglary under 292302A and 2911.12A3. You're currently charged with 2911.12A3, which is a second-degree felony, which carries a possible prison term of a minimum between 2 and 8 years set by the judge, and the maximum of up to half of whatever term the judge imposes will be added on by the Department of Corrections. The reduction to an attempt means that you engage in conduct which is successful or constitute a result of the offense. That reduces it by 1 degree to an F3. And F3s have a maximum penalty in prison of 36 months. There's a minimum of 9 different levels in between those two ranges. There's a fine of $10,000. You understand that?
Yes, sir.
Facing any felony charges in any other jurisdiction?
Yes, sir.
Are you currently on probation control, plea control, or post-release control from any other jurisdiction? Now, under the law, if you are convicted of this offense, upon completion of the prison term, it is required that you be put under post-release control for at least 1 year, could be up to 3 years as determined by the parole board. So you will be under supervision for at least a year and no more than 3 years up to as according to whatever the parole board determines. What that means is you'll be supervised, and the terms they set by a parole officer, and during that period of time they determine that you have failed to comply, they can return you to prison and make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of the prison term for all violations. But the violation, or if you've been a new felony while under post-release control, then in addition, whatever sentence the judge or new case can impose upon you, that judge could also sentence you in this case to an additional period of 1 year. Whatever time is left on that period of post-release control, whichever is greater, if that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control sanctions, which means instead of going to prison, you can be put under supervision of a probation officer for a period of up to 5 years under terms set by the court. If during that period of time, the probation department felt that you were not compliant, they would file a written notice of that to the court, serve a copy on you. You would have a hearing, and you would be entitled to have an attorney at that hearing. If the outcome of that hearing was that you failed to comply, then at that time, the court could revoke your community control and then sentence you to 36 months and fine you $10,000. You understand that?
Yes, sir.
Right now, the indictment alleges in count 1 that on or about August 8, 2021, in Manatee County, Ohio, that you and Lena Henry did by force, stealth, and deception, knowingly trespass on occupied structure, separately secured, separately occupied portion of occupied structure, purpose to commit in the habitation of criminal offense. So that's the violation of 2911.12A2. Now, to reduce that, then read that on about that date, you engage in conduct successful, would have constituted or resulted in that offense. You understand that?
Yes, sir.
And you're in agreement with the reduction, Mr. Undercover?
Yes, sir.
Okay. Now, do you understand that charge and what the state said you did when or how they let you do it?
Yes, sir.
Do you understand the possible penalties?
Yes, sir.
Now, you discussed the charge, the evidence in the case, possible legal issues of the case, possible defense on trial to raise the trial, possible outcome of the trial with your attorney.
Yes, sir.
Are you satisfied with this advice and confidence in this matter?
Yes, sir.
Have any threats been made to get you to plead guilty? Have any threats been made to get you to plead guilty here today?
Yes, sir.
Now, on page 3 or 2, there are 3 lines printed in bold toward the bottom of the page. Read as follows. Defendant shall enter a plea of guilty to count 1 as amended. State will dismiss count 2. State defense jointly recommend 24 months incarceration. Defendant shall pay full restitution and cooperate fully against co-defendant. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
Thank you.
Under the law, the matter of sentence is up to the judge, not the parties. So even though there's an agreement between you and the state, the sentence to be served if you plead guilty should be 24 months. The judge is not required to follow that. So if you plead guilty, once I've heard all the information, I could decide that's not the correct sentence. It could sentence you to as much as 36 months. You understand that?
Yes, sir.
And do we know what the restitution is?
$1,700, and that's joint and several with Lena Henry and Steve Gross.
All right. Lena Henry, who else?
Steve Ebros, he did a bill of information right after this case.
Oh, okay.
He had several charges, but
I'll just put joint several with co-defendants and adding that to the plea agreement. There's no dispute as to the restitution and Mr. Armstrong.
No, sir.
Do you hold any license or certification from any state agency or any occupational profession?
No, sir.
Right now, under the Constitution, you have certain rights you must understand before I accept the plea. First of all, you have a right to have counsel, Mr. Armstrong, who represents you, not simply to work the case out, but provide any defense that could be available to you under the law that you wish to provide. So, if you decide that you do not want to do this, you're still going to be represented by counsel through the trial if that's what you want. You understand that?
Yes, sir.
Under the Constitution, you have a right to have a jury trial in this matter. Mr. Woodruff, in which 12 people be selected from a group of citizens that live in this county that are summoned for jury duty and undertaken in your trial day. After those 12 were selected, the evidence will be presented. They then be instructed on the law by the judge, and they will decide by unanimous verdict, meaning all 12 have to agree as to whether or not the state proved your guilt or proved beyond reasonable doubt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. In that case, you have what's called a court or bench trial, meaning that the judge would be the one who would hear the evidence. The judge would apply the law. The judge would decide whether or not the state proved your guilt by proving beyond reasonable doubt. You understand that?
Yes, sir.
Constitution, Mr. Woodruff, you have a right to confront witnesses against you and cross-examine for your attorney. What that means is the witness against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor then asks the question, your attorney asks questions, that's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Under the Constitution, Mr. Woodruff, you have the right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, it's your request, the court issues a court order that will subpoena. That forces those people to come to court and be able to testify if they want them to, even though they don't want them to be involved. Same way the state's witnesses are forced to come in court to testify against you. You understand that?
Yes, sir.
Under the Constitution, you have privilege against self-incrimination, which means that you cannot be forced to give evidence against yourself at any time in this case, including trial. So no one can ever make you testify. The prosecutor can, the judge can, you decide. You decide not to testify. The fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation, which is if there's a jury trial and you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right now, in the Constitution, you have a presumption of innocence, which means you're presumed innocent until proved guilty by the state on every essential element of the offense charge. So the burden isn't on you to try to show you're not guilty, the burden's on the state to prove that you are guilty. Back at trial, you don't even have to present any evidence for a defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt of every essential element of the offense charge by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that? Now, originally you pled not guilty plea, denied the allegations, denied you committed any crime, and then exercised and revoked all of your rights that I've just described. If you change your plea from not guilty to guilty to the amended reduced charge of attempted aggravated burglary, then that plea would be the opposite of the not guilty plea. The guilty plea would admit the allegations in the amended indictment count 1, admit that there are crime, that you committed that crime, and that plea would waive give up all the rights that I've just described for you, except the right to have counsel, which you always have, no matter what your plea. Quote that exception, your plea of guilty would waive give up the right to a jury or court trial, would waive give up the right to confront witnesses against you to cross-examine for your attorney, waive give up the right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty to the state, then that's what you find guilty. It would waive or give up the presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It does subject you to being sentenced immediately by the court, and finally it waives gives up your right to file an appeal. I think you could have had up to this point in the case. Now, if I sentence you to the maximum sentence, or under the certain circumstances, you can file an appeal, but that would have to be filed in 30 days for sentencing it to be applied. You understand all that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Right now, do you have any questions about the charge and possible penalties? You understand? Any questions about the plea agreement?
Yes, sir.
You understand? You understand I'm not bound by the sentencing recommendation. You have any questions about the constitutional rights of the claim?
Yes, sir.
You understand it? Any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
Yes, sir.
You understand all the rights?
Yes, sir.
So anything you'd like to speak to Mr. Armstrong about before we go any further?
Yes, sir.
You have any questions about anything I've explained? Then it's your decision to withdraw your not guilty plea and plead guilty to the amended charge as set forth in count 1 of attempted burglary.
Yes, sir.
Okay, then as the charge in count 1 is amended, which would read that on or about August 8, 2021 in Huntington County, Ohio, you did purposely and or knowingly engage in conduct which, if successful, would have resulted in you by force, stealth, or deception, knowingly trespassing in an occupied structure, and a separately secured or separately occupied portion of occupied structure for purpose of committing habitation, criminal offense, violation section .911.12A2. The revised code charge of attempted burglary, a third-degree felony, and possible prison term of between 9 and 36 months, and anything provided by law, fine of $10,000. How do you put it? Thank you, receive. All right, the court finds on this date of the court, defendant was advised of all his constitutional rights, made an only token of voluntary waiver, saying pursuant to Rule 11, please accept the order filed, defendant's not guilty of the offense as charged in count 1 as amended, attempted burglary, count 2 is dismissed. Now, there is a brief sentence recommendation. I believe this is kind of sort of previous prison term.
Yes, or you have a previous felony.
Previous felony, all right. So I'm not going to order a pre-sentence investigation, but as I understand his request for deferred sentencing.
The December sentencing, that's agreeable with whatever they have.
When's the defense trial set?
Not until January now. Well, I'm assuming it'll move to January.
Okay. All right, well, I'm going to go ahead and set the hearing then for sentencing on December the 1st at 9 o'clock. And so if we need to meet with the prosecutor's office, it should direct to get your statement against the defendant, because that is a condition of your plea, is that you cooperate in that prosecution. And bond will be continued until that day. So we can get a signed note here from the bailiff. He did not need to appear on November 15th. That trial date is continued.
Your Honor, if I may, he's on house arrest, currently living in Urbana, aren't you? He has to see the probation officer today. He'd like to be able to visit his sister who lives in Piqua. She's undergoing chemo and radiation right now. He said it's about 30 miles away.
All right. I'll put that in the defendant can visit sister. She, at home or in the hospital?
He's at home.
Don't say you can visit her in Pickwa or any hospital. Just make sure you talk to the probation department, get out there and talk to them today, so that you get that, and let them know. But there's no precinct report, so you don't have to do that. All right, anything further, council?
Doesn't,
No, Your Honor, thank you.